Charlie Savage is a Washington correspondent for the New York Times. His latest piece is titled, "Trump Claims He Declassified All the Documents at Mar-a-Lago. Even if that's true, it probably doesn't matter." And Danya Perry served as a New York State federal prosecutor as well as New York State Deputy Attorney General. It is good to see you both. Charlie, Donald Trump is trying to argue that he declassified the documents in his possession. But as you write, quote, "The Espionage Act makes no reference to whether a document has been deemed classified. Instead, it makes it a crime to retain, without authorization, documents related to the national defense that could be used to harm the United States or aid a foreign adversary." So what he's arguing doesn't even matter, Charlie.
That's right. All three of the criminal laws cited in the search warrant do not turn or depend on whether the information was classified. So maybe Trump's lying, maybe he's telling the truth, and he sort of waved his hands over these documents on January 20th at 11:59 a.m., right before Biden took the oath, and deemed them unclassified. It doesn't change whether these laws would apply. The Espionage Act was written in World War I, about 30 years before presidents created the classification system, and it exists independently of whether something is considered classified or not under that system. And the standard you just read is the one a jury would have to decide whether or not the documents met. Whether or not Trump had magically invoked his power until he'd ceased being president to declassify them wouldn't change whether or not that standard had been met. And the other two statutes cited in the search warrant also don't have actually anything to do with national security information. Concealing documents to obstruct an official investigation doesn't say anything about whether or not those documents had to be classified or not. And the third one has to do with theft, destruction, concealing, unlawful taking of government documents or records in general. Again, does not have to be classified or unclassified, doesn't have to have anything to do with national security. And in fact, part of what they were looking for was any presidential record created from 2017 to 2021 that was, for some reason, being hoarded at Mar-a-Lago rather than being deposited with the National Archives as the law required.
Danya, lots of outstanding questions. One of the things we do know is that this search warrant was based on probable cause that Mar-a-Lago contained evidence of obstruction of justice and violation of the Espionage Act. What can we extrapolate from that?
Just that an agent had to swear under oath that there was probable cause to believe that violations of these three statutes had occurred, and that there was probable cause to believe that evidence, fruits, or instrumentalities of those crimes could be found on the premises, and that there was fresh evidence of all of that. So something, we've heard a lot in the news about conversations that have been going on for some time with the former president, but they had to have had information that the evidence was still there and pretty precisely where it was. And a judge had to independently find that there was probable cause to issue the warrants. So it's a pretty significant process with several steps. And as we know, it went all the way up to AG Garland for approval.
Charlie, you literally wrote the book on the expansion of federal authority in this country. The president does have close to absolute power for declassification. I did like the reference you made to him magically declassifying all of this. I mean, doesn't he have to at least tell someone that he's declassifying? It doesn't have to be some record of the declassification.
If things were being followed in the normal course of events, yes, there would have to be written records of this. Documents would have to have the top secret or whatever markings removed from them, as there'd be a process. If these were nuclear documents that people have been talking about, there's a process of consulting the Department of Energy and the Department of Defense first. Arguably, those restrictions might not apply to a president who does wield sweeping constitutional authority over this. The president, as an institution, created this system by executive order, and one could argue he's not bound by the regulations that lower-ranking people in the executive branch have to follow. But whether or not that happened, again, is irrelevant. These three laws do not depend on whether the documents were classified or declassified, had ever been classified in the first instance. It doesn't matter for the purpose of these three crimes that we now know the FBI is investigating.
Charlie, where do you think we go from here?
Well, the FBI has in this document we saw today, obviously has a lot of documents to go through. It took out, 11 sets of documents, some classified, some not, some classified at different levels, boxes and boxes of stuff. It's got to go through it. It's got to index it. It's got to understand what it has. And then they've got to make a decision whether they have enough information to bring charges. Clearly, they have other information that went into this search warrant, which is how they knew there was stuff there and where to look for it, and how they were able to meet that probable cause standard to a judge. We don't know what that other evidence is because they did not release the application for the search warrant, which would contain an affidavit listing, we are talking to these people. We have seen this surveillance footage or whatever. And so they have all of that now at their disposal, and they're going to be probably coming up on a tough decision. Do they bring charges or not? A big search like this, which alerts the defendant of what's going on, is usually pretty late in the process of an investigation.
Charlie Savage, thank you so much for being with us. Danya Perry, to you as well. Still ahead, the